Ladies and gentlemen, this is regarding an appeal. Now, most people don't know when you are doing an appeal, you have to request a stay if it's involving your property. If you were in state court, if you were a lawful detainer or whatever, if there is any judgment against you, even if it's involving just your so-called doggy or your so-called Amarol bottle that was sitting on the curb and some car rolled over it and then slipped and crashed into a tree, doesn't matter what the decision of the court is. You must first ask for a stay in the court that you're in, and then you must ask for a stay in the appeals court when you do your appeal. Pay attention to this stay request. We're going to let Natural Reader, it's a natural reader, so it's going to read for us, okay?
The aforementioned is accurately attested on this April 16, 2018.
That's my fault, people. You have to, with Natural Reader, you have to put the mouse there. Get off of that. I don't want just that sentence, so stop it. It ain't letting me do it, dude. Let's do it that way. Can't use that.
The appeals court stated that one did not give a reason whereby a stay can be issued, yet I do recall specifically stating that the lower court came to a decision based on the fact that title had not been perfected, that tender of payment had been presented, and that the property was in a pending adverse possession suit. Each of these alone renders the court that make the decision to continue with the unlawful detainer without jurisdiction. So my specifically challenging the jurisdiction of the court because it lacked the jurisdiction to make a ruling, because it was without authority, because the sale of the property to the so-called defendants was done while the property was in bankruptcy. This is a violation of the statute, violation of jurisdiction, as once the home was placed in bankruptcy that made it federal jurisdiction. There has been no evidence placed on the record by the defendants that they had leave of the federal court to proceed while the matter was in bankruptcy. There is no requirement in any law that says that I have to spell out to the court what the law is. The moment I told the court that the matter was in bankruptcy and the trustee was without jurisdiction to sell the property, the issue had nothing to do with nothing else other than the fact that the trustee did not have any authority to operate while the property was in bankruptcy and get the presumed and/or assumed to have had his authority. He would have to present such authority and independence. Would have to present such authority on the record. The burden of proof would not be shifted to myself, but it would remain what the defendants. To date, the defendants have not put forth any such burden of proof, and I do not have to bring forth their burden in order to prove to this court that it needs to, must follow the law. When I brought to this court's attention that the property was currently being adverse possession under the laws for the great state of Washington, that is enough to have notified the court that the superior court was without jurisdiction to rule while the other case was pending without some sort of a judgment from the other court or leave of the court to proceed while that matter involving that property, dealing with adverse possession, was pending. Adverse possession is for possession of the property, unlawful detainers for possession of the property. One judge in the ST court cannot overrule a different judge in the same court. This body knows this and yet it ignored the rule, ignored the law, ignored.
Okay, ladies and gentlemen, let me explain what's going on. When we challenged the court's decision based on the fact that the trustee sold the property while the property was in bankruptcy, on its own motion, the trustee said, I'm moving forward anyway. I don't care about no bankruptcy court. We're asking the question, did he have the authority to do that? If he didn't have the authority to do that, then everything that proceeded after that is a lack of jurisdiction for the court. It doesn't give the court any jurisdiction to act. The court cannot condone the actions of the trustee. If the court were to condone that, that means that it was saying what the trustee did was 100%, that he could do what he did. We're saying no. Okay, that's what's going on. Hold on.
My rights, and I object. When I brought to this court's attention that the lower court had not obtained legal jurisdiction, that wasn't enough. I'm not for the court to present a temporary stay pending the perfecting of the appeal. Is that not why there is such a remedy at law in the first place? I must now challenge the jurisdiction of this court, and as this constitutional question. Does or doesn't a party have the right to be before the judicial branch of government in all legal proceedings? Does or doesn't a party have the right to have their matter heard before a constitutionally sanctioned member of the judicial branch officer? Because the appeals court sits as an administrative reviewing body, does it do so in the capacity of a constitutionally authorized judicial branch of government agency or an administrative agency governed by the Administrative Procedures Act Article 5 of the United States Code? Because we are in a banking holiday as declared by Congress and the President of the United States, 2/3 of the American government, and documented by the Act of March 9, 1933, and Proclamations 2038, 2039, and 2040, are the intentions of Congress during that enactment and proclamation hold sway in this venue and jurisdiction? Since Congress has declared the national emergency to still be extant, as documented in the notes and in the act known as the National Emergencies Act. That means that this is a federal matter involving a government obligation. Either way, it would mean that first, there could be no demand for payment of the debt while the United States is in a current bankruptcy. We are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the United States government. Congressional Record, March 17th.
Now, do you guys see what I just did here? Not that stuff up there. Don't worry about that. I'm just correcting some verbiage. But we're saying since Congress declared the national emergency to still be extant, and they did do that by the National Emergency Act, it says as documented in the notes and in the act known as the National Emergencies Act. Okay, let's do that capital E. And I believe it's just, I'm going to do, yeah, let's do this right here. Right here. That, and that. Okay. National Emergencies Act. That means that this is a federal matter involving a government obligation. Hold on. Let's get to the end of the shion. Okay. Either way, it would mean that first, there could be no demand for payment of a debt while the United States is in a current bankruptcy. How do we know the United States is in bankruptcy? Because congressional record shows that the members of Congress has declared this. Pay attention. Pay attention. Okay? Let's do H-1303. All right. Follow this. We are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in the world. United States is the entity. The United States government. Okay? They're saying that the corporation is bankrupt. It's okay. I know that John Trafficant said this, but he said it on the floor of the Congress. Did anybody object? Did anybody interrupt? Did anybody say, you're a fool, John? You're going crazy. You would perhaps convince me too if I was to give you more time. Nobody said anything like that, did they? Of course they didn't. So now we say Congress, since nobody rebutted what he said, and it was said on the official floor of the Congress that this was the official stance of the United States Congress, as it was common knowledge to all of them, that the United States is in a current bankruptcy. That's how I play. That's how I roll. Hold on.
1993. P.H. 1303. Because the United States Congress in the Act of June 5, 1933 has made it clear that such a demand would be against public policy as it would interfere with the United States Congress's delegation of authority to regulate the currencies of the United States.
The demand is a demand for a debt.
I believe it unfair to place my matter before a commissioner without my consent, without giving me the opportunity of saying no, I do not consent. Please let me make it clear I do not consent. Because it is clear in law that no one may convert a right to a privilege, the court cannot deny me the right to a stay of any action by the lower court when its officers have acted without discretion, without jurisdiction, and without delegation of authority. To do so would be to deny me what is mine as a right, and it would be to condone what the superior court proceeded to do, sanctioning their actions, and denying them a right to affirmative relief. Please note that the above questions are not federal questions, they are state of Washington constitutional questions. The federal questions are as follows. While the matter was pending before the United States Bankruptcy Court, did the lower court have jurisdiction to proceed while the matter was pending in federal jurisdiction? While the matter was pending before the United States Bankruptcy Court, did the securitization trustee have jurisdiction to proceed with the sale of the property while the matter was pending in federal jurisdiction? Since the federal government has stated officially that legal tender has no value in the United States pending this bankruptcy since 1933, Federal Reserve notes are not redeemable, and receive no backing by anything. This has been the case since 1933. The notes have no value for themselves. https://www.treasury.gov/resource-center/faq/currency/pages/legal-tender.aspx, an official website of the United States government. The state must provide a remedy for the current crisis, and I to understand that this court does not recognize the obligations of government, and that all debt in the United States is construed as a government obligations. If the answer to the preceding question is no, that the matter did not involve a government obligation, Then please explain the congressional intent with reference to the following congressional notes of the congressional record for the enactment of the
Oh,
March 9,
snap. Watch this,
1933
y'all.
Emergency Economic Banking Relief Act. The ownership of all property is in the state. Senate Document Number 43, 73rd Congress, First Session. Under the new law, the money is issued to the banks in return for government obligations. The money will be worth 100 cents on the dollar, because...
Did you guys not pay attention to what Congress's intent was all the time? As a matter of fact, I'm going to do that. Watch this. We're going to do this, and then we're going to see colon 12 USC 411. 12 USC 411 says exactly what this is saying, and this is from the congressional record. The only thing I did was took out the verbiage that talks about bills of exchange and all the other junk. But under the new law, the money is issued to the banks, not to the people, in return for government obligations. So you don't have any access to money because it was never the intent of Congress to give you access to money. They only issued it to the banks. USC 411 says that. It says the money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and all the property of all the people of the nation. Okay? Just wanted to point that out because many people may not have been picking up on that. Pick up on it, people. Pick on up on it.
It is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people of the nation. Congressional Record, March 9, 1933 on H.R. 1491 p. 83. Am I correct in understanding that the government is supposed to supply and provide a remedy to the national community, otherwise known as the people? Does this body recognize equity? Am I not entitled to equitable relief? Is a stay request in proceedings such as this not considered an equitable request? However, even if I were to have been asking for administrative relief, this court was to have recognized the rules of equity, that equity must bring equity. It failed to do so. The clerks of the court, including commissioners and/or judicial pro tems, cannot make judicial decisions and/or judicial determinations without consent, as neither of them are elected officials, elected by the people to the positions of judgeship. If my presentments are unacceptable in light with the table of authorities aforementioned, please be specific. If not, I must insist that you stop interfering with my right to access the court. The aforementioned is accurately attested on this April 16, 2018.
Okay, ladies and gentlemen, the reason for that is, again, the court was trying to dismiss this young lady's presentment. And he just basically said, denied, you failed to state a reason for the stay. Excuse me? Denied, you failed to state a reason for the stay. Of course we stated a reason. And that's why we put in here, we don't have to explain to you every single nooks and crannies of the process. We don't need to give you every single opportunity to come up with a reason to deny us. No, basically the only thing the law requires us to do is bring the matter to your attention. So when we said the trustee did not have the authority to sell the property while the matter was pending in bankruptcy, ladies and gentlemen, guess what? Got to get rid of that apostrophe. That was the only issue. It had nothing to do with us explaining why the trustee did not have the authority and why the bankruptcy court must issue a decision. They already know that. Why are we having to tell them that? We don't have to. That's the point. But we told you guys we wanted to ask federal questions. So ladies and gentlemen, go back over the video. These questions right here are my state questions. They can be better, but this is on the fly. I just came up with this a moment ago. That's why I recorded it. That's why I put it up here for you guys to see where I'm going, the way my questions are being asked. Did you notice how I put this question? Since the federal government has stated officially that legal tender has no value in the United States during the pending bankruptcy since 1933. Now, we're going to put apostrophe, a comma, not an apostrophe. Well, an apostrophe and a comma, the same thing, just one different position than the other. What did I tell you? Oh, by the way, ladies and gentlemen, somebody sent me an email today regarding my video on the AIDS epidemic. And the person was telling me that he wasn't really commenting on the video, but yet he refers to the video and then gets not so happy with the fact that I tell him, I told you people not to do that, and I'm going to give you a pass because you and I have communicated in the past. And seems like he kind of got tits for tat. I don't care. Do it again, and I will block you. Nobody. Sorry, I apologize. I get tired of having to say the same thing over and over again because, see, when I just do stuff, people think that I'm mean, I'm angry, and I don't care and all that other bull crap that they want to say. I get tired of people ignoring me as if when I tell them not to do something when it concerns my stuff and they do it anyway when it concerns my stuff. You don't have a right to communicate with me any way you want. You don't even have a right to communicate with me unless I offer you the opportunity. Okay? So please stop thinking that you have this or that right. Now let's get back to the Federal Reserve. Federal Reserve notes are not redeemable. Just that simple. And not redeemable in gold. They're not redeemable in anything. They receive no backing by anything. So if they have no backing, you can't redeem them. Sorry. This has been the case since 1933, since the bankruptcy started. The notes have no value for themselves. It doesn't mean they have no value unless, no, if they had value, they would have said they only have this value. Other than this, they have no value. They didn't do that. They said they have no value for themselves other than what they can buy. Excuse me? What they can buy. Excuse me? What they can buy. I thought they received no backing by anything. I thought they are not redeemable in anything. In order for them to be able to purchase something, they have to be redeemable. That's what redemption is. Shawshank. Anyway, let's continue. The state must provide a remedy for the current crisis. Am I to understand that this court does not recognize the obligations of government and that all debt in the United States is construed as government obligations? Now, pay attention because we went one step further in explaining to these idiots, watch this. If the answer to the preceding question is no, that the matter did not involve government obligations, then please explain the congressional intent with reference to the following congressional notes of the congressional record for the enactment of the March 9, 1933 Emergency Economic Relief Act. And then we take those notes and we only highlight exactly what it says. We don't add nothing, newton tootin'. Hold on. The ownership of all property is in the state. So how can someone else claim ownership of my property when it's the state and the state needs to foreclose on my property? And since it is a government property, how come nobody contacted the Attorney General? That's what we're going to be saying in the appeal. Under the new law, the money is issued to the bank in return for government obligations. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and all of the property of the people. So excuse me, wherein is my remedy? The law says that the court must give me remedy. Must give me remedy. The court ain't giving me remedy. The court must give me, and ladies and gentlemen, individuals can make equitable requests, but they have to ask for, see, even if I were asking for administrative relief, I'm not asking for administrative relief. I'm asking for affirmative relief. This court must recognize affirmative relief. Let me see if I got that in here. I know I got affirmative relief in here because I put it in here. Let me find it, y'all, because this video is about to end. Affirmative relief, denying me the right to, denying me, glad I did that, the right to affirmative relief. I'm glad I did that. That's why we deal with the questions, okay? The top questions were not federal, but now we did the federal and state. See, I told you guys we have to come up with federal questions for the federal court. Well, you saw the way I will do my federal questions. I just haven't done them yet. So I'm putting this before you guys. Hey, everybody, I'm glad that you allowed me to bring forth this appeal document so that you can see a response to the court regarding a stay. All right, have a good day, everybody. Have a good night. Have a good life. Have a good bye.